The air inside the United States Supreme Court chamber was electric, charged with tension, curiosity, and the kind of silence that only precedes the unexpected. All eyes turned as Elon Musk stepped forward to the petitioner's lectern. Dressed in a sharply tailored navy blue suit, he adjusted his tie with a brief flick of his hand, an almost imperceptible gesture of unease from a man more accustomed to launch pads than legal briefs. Today, there were no attorneys flanking him. No legal giants speaking on his behalf. Against all advice and expectation, Musk had elected to argue his own case before the highest court in the land. Across from him sat Chief Justice John Roberts, the enduring steward of the court's institutional integrity, and Associate Justice Amy Coney Barrett, the intellectual sharp edge of the conservative bench. The two exchanged a glance, neutral to the untrained eye, but not to the seasoned observers in the gallery. It spoke of skepticism, amusement, perhaps even a dash of disdain. "Mr. Musk," Roberts began, his voice composed but unmistakably cool, "you've made the unusual decision to represent yourself before this court. While you are entitled to do so, I must remind you, this is not a TED Talk, nor a live-stream debate." A ripple of cautious laughter moved through the courtroom. Justice Barrett leaned forward, her voice carrying the kind of practiced condescension that law professors reserve for overeager students. "The legal questions before us today are extraordinarily complex. Are you certain you wouldn't prefer to leave this matter to counsel?" Musk did not smile. He did not flinch. His gaze swept across the bench, and for a moment, the man known for spontaneous tweets and interplanetary dreams seemed every bit the calculated strategist. "I appreciate the court's concern," he said, his tone formal, measured, and devoid of the usual bravado. "But the stakes of this case go beyond statute. They touch the future of human communication itself. And that, Your Honors, is a frontier I know intimately." The justices blinked. Roberts, ever composed, raised an eyebrow. Barrett narrowed her eyes. A shift, subtle but real, passed through the chamber. This was not the opening they had expected. The case, Musk versus Federal Communications Commission, was already being called the most consequential digital speech case in a generation. At issue, whether the FCC had overstepped its authority by mandating content moderation algorithms on platforms hosting user-generated speech. The lower courts had sided with the government. Billions of dollars and fundamental operational changes loomed over Musk's platform, X. But Musk, driven by more than financial interest, saw something deeper, a threat to the foundational principles of digital freedom. Chief Justice Roberts leaned back, adopting his familiar Socratic stance. "Your core argument, Mr. Musk, is that the FCC lacks statutory authority to impose these algorithmic requirements. But the Communications Act grants the Commission broad latitude in regulating interstate communications. Why should we carve out an exception for your platform?" A textbook opening volley, designed to force even seasoned attorneys onto the defensive. But Musk didn't blink. "Chief Justice, with respect," he said, voice calm, "the Communications Act was written in 1934, an era when communication meant radio towers and rotary phones. It has since been amended, yes, but the provisions cited by the FCC were never intended to govern algorithmic architecture or global speech platforms. To pretend otherwise is not interpretation. It's invention." Barrett's voice cut in, sharp as a scalpel. "Yet this court held in Massachusetts v. EPA that statutes can adapt to new technologies, even when the drafters could not foresee the specific applications. Greenhouse gases weren't in the minds of legislators in 1970, yet we ruled they fell under the Clean Air Act. Why should we treat digital algorithms any differently? The trap, or so it seemed. But Musk didn't step around it. He stepped through it. "With respect, Justice Barrett, that precedent supports my argument. In Massachusetts, greenhouse gases fit squarely within the statute's original definition of air pollutant. The application was novel. The framework remained intact. But here, the FCC isn't just stretching the law, it's reimagining its purpose. It seeks to shift from regulating communication infrastructure to policing the content of speech itself. That is not a statutory stretch. That is a jurisdictional transformation." The room quieted. Somewhere in the back, a seasoned appellate journalist scribbled, "Stunning," in her notes. Justice Sonia Sotomayor leaned forward. Her voice carried the weight of a seasoned jurist unswayed by flash or fame. "Mr. Musk, your platform reaches hundreds of millions. When misinformation spreads, the consequences are tangible on public health, on elections, on national security. Why shouldn't the government have the authority to regulate it, just as it does with broadcast media?" Musk exhaled, slowly, choosing his words with surgical care. "Justice Sotomayor, the comparison to broadcast fails on three fronts. First, the airwaves are a public resource, inherently scarce and uniquely invasive. Digital platforms are neither. Second, users opt in to digital discourse. They don't passively receive it. Third, and most critically, our content is created by users, not programmed by us. That makes us facilitators of speech, not broadcasters." There was a pause. Not from Musk, but from the bench. What had begun as a presumptuous billionaire's gamble was beginning to feel like something else entirely. The mood in the chamber had shifted. What began as an unspoken effort to rein in an overconfident tech mogul had become something else. An encounter neither Chief Justice Roberts nor Justice Barrett had anticipated. Justice Neil Gorsuch, known for his wariness of administrative overreach, leaned in. His tone was neutral, his question anything but simple. "Even assuming your statutory interpretation is correct, Mr. Musk, why should we not defer to the FCC's technical judgment under Chevron? Isn't this precisely the kind of ambiguity Congress intended agencies to resolve?" It was a pivot into the heart of administrative law, a domain where many advocates, even those with decades of experience, floundered. But Musk, prepared with the precision of an engineer and the foresight of a strategist, didn't blink. "Justice Gorsuch, I respectfully submit that this case implicates the major questions doctrine, not ordinary administrative interpretation," Musk replied, his voice steady. "In West Virginia v. EPA, this court made clear that when an agency claims the power to reshape the economy or exert vast political influence, clear congressional authorization is required." He paused, then added, "The FCC's proposed mandates would force our platform, used by 2 billion people worldwide, to fundamentally alter its architecture, suppress constitutionally protected speech, and elevate federal oversight into every interaction on our platform. If that's not a major question, I don't know what is." The words landed hard. Gorsuch's expression was unreadable, but he offered a slight nod. Then came Barrett again, this time with a glimmer of intellectual curiosity behind her sharp tone. "Your briefs cite Professor Lawrence Lessig's theory of code as law. That architecture itself can function as a form of regulation. Could you explain how that concept applies to the FCC's regulation here?" A lesser advocate might have faltered at the leap from black-letter law to academic theory. Musk did not. He stepped back slightly from the lectern, his voice now imbued with quiet authority. "Justice Barrett, that framework is central to my argument. Traditional law regulates through rules and enforcement. But algorithms, code, regulate in real time, invisibly, automatically, and without due process. When the FCC mandates the use of specific moderation algorithms, it isn't just regulating behavior, it's embedding law into the digital architecture itself." He spoke now not just to the bench, but to the nation beyond the marble walls. Consider Section 4B of the FCC's proposal. It requires platforms to suppress potentially misleading content, but gives no clear definition of what that means. To comply, we'd need to deploy predictive filtering that preemptively suppresses speech based on probability, not proof. That's a form of prior restraint, Your Honors. And this court has consistently held such restraints to be among the gravest threats to the First Amendment. Justice Roberts leaned forward, no longer dismissive, but engaged, keenly so. "That's a persuasive theoretical argument, Mr. Musk. But let's talk about the real world. How would you propose we address legitimate harms, like foreign disinformation campaigns, without algorithmic oversight?" It was the crux. The bridge from liberty to security. Musk did not hesitate. "There are constitutionally sound paths forward," he said, lifting a neatly tabbed folder and laying out his alternative framework. 3. To be specific. First, mandatory transparency. Platforms should be required to publish algorithmic logic and moderation practices. Second, user empowerment. Give individuals tools to control what they see rather than imposing top-down controls. Third, narrowly tailored enforcement. Focus on illegal content categories, not broad suppression. Then came the part that truly seized the room. Each of these alternatives is grounded in existing statutory authority, Musk continued. The Federal Trade Commission already has the power under Section 5 to require disclosure of unfair or deceptive practices, including opaque algorithms. And if additional authority is needed, it should come from Congress, not an agency acting unilaterally. Justice Barrett's brows lifted. She was no longer skeptical. She was impressed. Your framework, she said, seems to draw from Justice Kennedy's concurrence in Packingham versus North Carolina regarding the Internet as the modern public square, while respecting the government's interest in preventing harm. Have you considered the current statutory landscape enough to ensure your model is viable? Musk nodded. His voice softened just slightly, signaling respect, not retreat. Yes, Justice Barrett. In fact, I believe Congress could enact targeted amendments to Section 230 to clarify liability boundaries while preserving user rights. But even without such reforms, the core of my model already exists in law. It simply requires a recalibrated approach, one that balances liberty with safety without sacrificing the Constitution on the altar of convenience. The Solicitor General, seated quietly at the government's table, shifted uncomfortably. This wasn't just a defense. It was an offensive strategy, calculated, principled, and alarmingly persuasive. As the justices began exchanging looks, no longer of amusement, but of serious reflection, the courtroom observers understood what they were witnessing. The justices weren't just hearing arguments. They were listening. 3 weeks passed. In Washington, D.C., spring sunlight poured over the marble steps of the Supreme Court as rumors swirled. Legal commentators speculated. Editorial pages debated. Cable news hosts circled the same question with fascination and disbelief. Would the Supreme Court really side with Elon Musk? Inside the court's private chambers, the mood was unusually animated. According to clerks, the justices' conference following oral argument had lasted nearly twice the norm. Musk's arguments hadn't just raised questions, they'd redefined the battlefield. Chief Justice John Roberts, long the guardian of the court's institutional restraint, found himself rereading sections of Musk's transcript late into the night. The clarity, the fusion of law and technical depth, the challenge to Chevron. Even Roberts, known for caution, couldn't deny that something significant had occurred. And then, without warning, the docket updated. Elon Musk versus Federal Communications Commission. Opinion by Justice Barrett. Decided, 7-2. The legal world paused. And read. Justice Amy Coney Barrett's majority opinion opened with a striking acknowledgement. This case requires us to confront an increasingly urgent question. How should the Constitution apply when regulation is no longer written merely on paper, but into code itself? Barrett recounted Musk's oral argument with unexpected candor. While this petitioner lacks formal legal training, his technical expertise and constitutional fluency offered this court insights both novel and necessary. Then she delivered the blow that would ripple through the legal establishment. The FCC's regulation, while motivated by a legitimate governmental interest, imposes algorithmic mandates that operate as prior restraints on speech. Such restraints, even when administered by code, are presumptively unconstitutional under this court's precedents. Barrett cited Neer versus Minnesota, Packingham versus North Carolina, and, most frequently, Musk himself. She affirmed the Musk framework, adopting key components, transparency requirements, user empowerment tools, and narrow tailoring of enforcement. The court ruled that while the government may regulate disclosure, it may not commandeer platforms to rewrite their code in service of state speech preferences. To regulate the future, the law must respect the architecture of the present. When code becomes law, constitutional protections must follow it into the machine. Justice Sotomayor joined the majority, noting in concurrence, "I approached this case with deep skepticism, but I cannot ignore the clarity and constitutional logic of the petitioner's argument. What appeared to be arrogance revealed itself as something else, understanding." Only Justices Kagan and Kavanaugh dissented, arguing that the FCC's interests outweighed the constitutional risks. The fallout was immediate. Harvard Law School added the oral argument audio to its constitutional law curriculum within 24 hours. Yale Law Journal published a symposium titled Musk v. FCC and the New Frontier of Algorithmic Jurisprudence. In law firms across the country, young associates passed around annotated copies of Barrett's opinion like sacred text. Legal podcasts erupted with stunned admiration. "This wasn't just a win," said one former Solicitor General on national television. "It was a moment, the day the court met Silicon Valley on equal ground and didn't blink." Barrett, typically reserved in public appearances, spoke weeks later at a Notre Dame event. Reflecting on the case, she offered a quiet but telling admission. "The experience reminded us all that constitutional interpretation requires not only legal tradition, but a willingness to learn, especially from those outside our ranks." Chief Justice Roberts, delivering a rare keynote at the American Law Institute, echoed the sentiment. "As the machinery of society evolves, so too must the tools we use to understand it. Legal insight no longer belongs solely to the legal profession." As for Elon Musk, his public image underwent a startling evolution. He remained controversial, polarizing, unpredictable. But now, law schools and think tanks studied his arguments. Legislators invited him to testify, not about rockets or revenue, but constitutional design. A term emerged in tech legal circles: Musk jurisprudence, the belief that digital regulation must begin with transparency, user agency, and technical realism, not government-mandated code. Years later, when a group of Supreme Court justices were asked in an off-the-record session about the most unexpected moment of their careers, one clerk recalled Barrett smiling faintly and saying, "That day we tried to put Elon Musk in his place, and he walked us through a new chapter in constitutional law." And so, what began as a seemingly arrogant stunt by a tech billionaire became something greater, a transformation in how the nation's highest court thought about speech, technology, and the power of code. Not with bluster, but with brilliance.